Hi, good afternoon. It's Gabe Oberfield hosting this week, and I'm thrilled to be back with all of you. I wanted to welcome you to Business in 24, our weekly webinar presentation. And I'd like to go over some housekeeping rules. Kathy Purdy is normally the voice you hear at this point in our broadcast. She has another commitment right now. But to make sure that all of you are familiar with the rules of the road as they were, I will read them to you. First, if you have questions, as you're no doubt familiar, you can enter those questions in the question and answer box located at the bottom of your screen. And the panelists and I will do our best to answer those questions as time allows. We'll, of course, take those questions back following the webinar and answer those that we can't in the coming days. And then once the webinar has ended today, we would appreciate if you would please take the time to complete the survey, because what you put in the survey is read by people like me and by Kristen and other presenters. We're very interested in what you have to say because it helps us think about and then otherwise prepare topics that align with your interests for future presentations. So with that in mind, thank you again for tuning in. And Brian, if you wouldn't mind going to the next slide, I will walk through the one after that, please, would be even better. I'll walk through the agenda. Thank you. So here it is. It is June 25th in New York City, where I'm broadcasting to you from. Thank goodness it is a lot cooler than it was over the weekend, where I know it was similar for most of you across the state and even elsewhere in the country if you're tuning in. The heat has abated for a bit, and so that'll give us some time to focus on today's program, which is chock full. So I will get out of the way in just a moment, but let me tell you what the agenda and coming content looks like. I will address what's happening with the primaries that are taking place throughout New York State today. Seth Gilbertson, back on the webinar from our Buffalo office, will be addressing OCR activity, I should say, involving two high-profile universities. Interesting stuff there. Devin Karras, who is another New York City office member, who sits around the corner from me here, will be talking about competing beneficiary claims and 5,500 remittance reporting and correction, all of which is in the vein of important reminders for you to be thinking about in the employee benefits space. Nicole Macris is back with us from Syracuse, and she will be addressing fairly hot off the presses decision out of the Third Department, and that's Cuomo versus the New York State Commission on Ethics and Lobbying in Government, a really interesting decision concerning essentially separation of powers. And then Cecily Capo is making her debut on the program. Cecily, also with us from Syracuse, will be covering the proposed Federal American Privacy Rights Act, which is a big deal if it moves forward, and we wanted to give you all a flavor as to what that would comprise. But let's go to the next slide, Brian, and I can walk through my brief content. And our goal, of course, is to be complete with our programming overall within the next 40 to 45 minutes. But as far as primary day is concerned, depicted on the right of the slide, you see Representative Bowman and George Latimer, who are in a hotly contested primary that's been getting a lot of national attention. That's just one in New York today. The polling suggests that Representative Bowman has an uphill battle to win this one, but we will know more as the day concludes. As far as the first congressional district is concerned, Goroff versus Avalon, they are going head to head to be the Democrat that goes up against the incumbent in November. And same with Mannion versus Hood in the 22nd. There are a variety of assembly primaries also taking place in New York State that are worth noting. Two that I'll flag among the number there listed, and that's not the whole set. Those are just some highlights. Assemblymember Kim, who has been associated very strongly with the pandemic and nursing homes and specifically efforts to provide, in his words, additional transparency around what transpired within nursing homes during the height of the pandemic. He's facing a tough primary battle, and Danny O'Donnell is retiring after a generation serving the Upper West Side of Manhattan, and the primary is in many respects a proxy for the general election, because the Upper West Side is so heavily Democratic, and whoever wins today is likely to ultimately move into the assembly for the next term. So with that, we'll be keeping eyes and ears on all of those races, and we'll have more in future programs after the results are final. Next slide, please. We're also, thank you, Brian, paying attention to what's happening within the Supreme Court down in Washington, where we're waiting for opinions to drop. This is the week when it happens. The recess that the court takes is usually as between July and October. So we're expecting a lot of activity in these last few days of June. Relative to years past, the court is a little bit behind. So there should be some really significant movement, as well as information for all of us to digest over these next few days. So more on that in future programs. So just put a pin in that for now. And then I will, with that, ask Brian, please, to go to the next slide so that I can introduce Seth Gilbertson. And so Seth is with us from Buffalo, as I noted. Seth, if you wouldn't mind turning on your camera and unmuting, that'd be great. Thank you. And so Seth has been on the program really on innumerable occasions, is a voice to walk through issues that affect institutions of higher education. And in Seth's practice, he's come across the activities of the federal OCR as relating to two different universities. He's been writing on this too, and he looks forward to sharing an update with all of you. I look forward to hearing it. And Seth, thank you so much for coming back on the program. And we always appreciate what you have to say. The floor is yours.
Thanks, Gabe. Next slide, please. And I'll just note, Gabe mentioned two recent OCR decision letters or determination letters and resolution agreements. There's actually a third that was released yesterday that I'll be referencing as well. So these all relate to Title VI of the Civil Rights Act of 1964, which is the primary federal statute that the federal government uses to enforce non-discrimination rules related to race, color, national origin in governments or in programs that receive government funding, federal government funding, that is. You'll notice religion is not included as a factor that Title VI prohibits discrimination. However, Title VI has been interpreted and is interpreted to include discrimination based on shared ancestry, which often will include elements that are closely related to religion or closely identified with religion, such as shared Jewish ancestry, for instance. And in fact, that is the way that Title VI has been sort of in the news and the focus of enforcement actions, most recently on college and university campuses, where there have been an uptick, a pretty serious uptick in anti-Semitic and Islamophobic complaints of behavior, mainly related to protests associated with the war in the Middle East. So the Title VI applies to, I tend to think of it, in myopic point of view, tend to think of it as an education statute. It really applies to all entities that receive federal financial assistance, which will include many healthcare organizations, schools of all types, including colleges, universities, and K-12, many, if not most, government entities, and many sort of quasi-governmental entities, such as public authorities in New York State, would also be covered by Title VI. Generally, depending on the source of the federal funds that are at issue, that will govern which federal department has enforcement authority. The Department of Justice can also come in and utilize the enforcement authority and file lawsuits and enforcement lawsuits and things like that. We're primarily going to be talking about the U.S. Department of Education's Office for Civil Rights. There are parallel offices for civil rights in other federal departments, but today we're going to be talking primarily about OCR in the Department of Education context. Next slide, please. So basic Title IX compliance requires a few things. It's sort of the bare minimums. You need to have a policy that prohibits discrimination. You need to have some training and education, sort of awareness related programs that ensure that employees and participants in programming are aware of non-discrimination, aware how non-discrimination rules, and aware of how to file complaints. And then you need to have a complaint procedure. These complaint procedures have been the focus of the most recent enforcement activity that we're going to be talking about primarily today in a couple of those cases that Gabe had referenced earlier. Next slide, please. So recently, OCR has released, they've begun a very large number of investigations, primarily targeted at colleges and universities. They've been very public about these. We're talking about over 100 such complaints at this point. And many colleges and universities have been sitting around waiting to see, no, well, not sitting around, but anxiously awaiting to see what OCR is going to do with these complaints. Recently, we've had a couple of high profile, and then one sort of more recent complaint released against Lafayette University in Pennsylvania, where OCR has released its investigatory findings and published a resolution agreement that it released with the university. The universities are University of Michigan, the City University of New York, and as I say, Lafayette. There are numerous complaints that are still outstanding. So that's why we're watching these sort of public ones closely to see how they're resolved and what we can learn from them. A few things we can learn from them are that the university or college has an obligation to respond promptly and effectively to allegations and apparent harassment, including hostile environment, the activities that may create a hostile environment, such as many of the allegations are focused on the protests against the war in the Middle East and various aspects of that recently. One of the big questions that is still out there, in spite of these most recent pronouncements by the Office of Civil Rights, is whether or when speech that is harassment sort of crosses the line, or speech that is generally protected crosses the line into harassment. How do you address speech that looks like both? In a lot of cases, it's speech for the speaker and harassment for the recipient. So how do we address these things? OCR has basically been very forceful in saying you need to address them. You need to investigate them, and you need to address the hostile environment that's been created by this speech, but has not said nearly as much about how we're supposed to make those determinations and what we're supposed to do when, again, you have something that is generally protected speech, particularly if you're a public institution, something that is generally considered protected speech, but also creates a hostile environment for recipients or for other individuals who may hear and be associated with that speech. Next slide, please. So we don't have perfect results here, or because of the sort of lack of clarity in some of OCR's pronouncements on these issues. But what we can sort of divine by what we know so far is that you need to have a robust complaint handling mechanism. You need to have a procedure. You need to follow it. You need to do it right away when you receive a complaint or you receive information that could that would lead the institution to be aware, so you know or should have known of activity that would violate Title VI protections. Now's the time to review your policy. I can tell you many colleges and universities have policies on these issues that are not necessarily haven't been updated in a while. have not been an area of focus for the institution, and we need to focus on those now because of the significant uptick in enforcement. I would suggest using Title IX. We're all very busy with Title IX right now in the college and university world as we try to ramp up and get ready for the new regulations going into effect on August 1st. However, I think there are sort of some parallels between these two laws and how they are applied. There are shared process attributes that we can use. We can use similar investigative techniques, and hearing techniques, and decision-making techniques, and processes for both. So consider sort of using Title IX as a process to some of the processes that you have for Title IX, apply those to Title IV style complaints as well. I think they'll serve you well in many cases, and it's sort of a well-worn path that you can follow. Have a process for distinguishing free speech from harassment. Call your lawyer if you have a close case, because we need to figure out how to make these determinations in a way that is defensible down the road. In almost every case, one side or the other is going to be aggrieved by this. So you're oftentimes going to be the recipient of a complaint. When you make this determination, you want to be able to go back and walk through your process and show why you made the decision that you made at the time. Conducting proactive climate assessments is a good idea to figure out where your community is and what issues you can address to get out ahead of some of these complaints, and to make your institution and your campus a more welcoming place for everybody, and a place that's conducive to free speech and debate. And then finally implement training programs to make sure there are really two sort of sets of training programs that you need. One is really just an awareness campaign so that students and employees and folks like that are aware of what the rules are around non-discrimination and where to file a complaint. And then you need much more detailed training for the types of people that are going to be investigating complaints and making decisions related to those complaints. And that's what we know so far. We'll continue to be watching this area and to update the community as we find out more.
Seth, really helpful to hear, as you said, what we know now. And it sounds like this is fast moving and that you're watching it closely. So please come on back to the program when there are updates. And as always, thank you for taking the time. I'm going to switch to our next presenter then, Devin Karras, who is with us again out of our New York City office. And Devin, in his practice as a senior counsel, focuses on employee benefits and all their emanations, and thought it was a good time to hop on the program to provide a set of important reminders. And today what Devin's intending to cover are competing beneficiary claims and 5,500 remittance reportings and corrections. And so, Devin, you know more about this than I, so I look forward to hearing from you and learning, and thank you for coming back on today.
Sure. Thanks, Gabe. Happy to be here. Hi, everybody. It's been a minute since I've been on one of these afternoon sessions, so happy to be back. I'm covering two topics today really very quickly. As Gabe said, these are more or less reminders, but I'm actually kind of soliciting thoughts from the listening audience here about any topics that are ERISA, 401k, DB plan, health and welfare plan, cafeteria plan, or executive comp plan related, that you'd like any of us in the employee benefits group to discuss on any successive Tuesday sessions. Right now, there's a lot of the regulatory space is relatively quiet for ERISA practitioners, so we're always happy to field questions that are common amongst our listening audience, and you know, there's oftentimes random questions that would be helpful for everybody to hear. So feel free to let me or Gabe know when this is over if there are any topics that you think would be of interest going forward. So with that said, the first topic I'll be discussing today is sort of a reminder about that plan sponsors remind their retirement and health and welfare plan participants to regularly review and update their beneficiary elections. This is something, a recent question that I've had from some clients, and they're coming up with more frequency, which is kind of surprising. So I'll just give you one fact pattern, which is kind of heartbreaking and tragic, which is not uncommon when we get these competing kind of claims for benefits here. So we had a client who they had a plan participant who was a single mother with 2 adolescent children, and the mother named both of her kids as her retirement plan death beneficiaries. The mother subsequently remarried and unfortunately passed away tragically not terribly long after her marriage. And the question that I was asked was, does a surviving spouse's interest as a surviving spouse supersede the children's interest as named beneficiaries? Because by law, the surviving spouse in a qualified plan is typically the primary default beneficiary under a tax qualified plan. So after some digging, and there's actually a linchpin case regarding how to resolve issues like this. It's the 2009 Supreme Court case Kennedy v. DuPont, and the fact pattern in that case wasn't that much different. In that case, there was a plan participant who elected his spouse as his primary beneficiary under his retirement plan, and the husband and wife got into a very heated divorce. And the divorce decree specified that the spouse of the participant waive any right or interest related to the plan participant's pension benefits. Not long after the divorce, the participant later died, but in the course of all this, he never actually changed his beneficiary designation in accordance with the plan and plan procedures. The plan document governing the beneficiary designation said that rights to the ex-spouse were essentially governed by the beneficiary designations on file, and that they would remain on file and in effect unless otherwise amended by the participants in accordance with the plan. So because you have a deceased participant who never revised his benefit election, his ex-wife, whom he really hated, obtained a windfall to the chagrin of the participant's other relations. His brother in particular, I think, was and his estate were really upset about the outcome. The key here is that the Supreme Court allowed the plan administrators to look to the plan and the plan language and lean exclusively on what the plan language said when in resolving an apparent conflict between what the plan document said and a separate divorce decree where the ex-spouse expressly waived her interest to the deceased participant's plan benefits. So ultimately, the outcome was not what the participant or his brother and his estate had hoped for. But ultimately, I think the decision was sound because it basically underscored the importance and the reminder that plan administrators and sponsors kind of look to the plan to resolve these issues. And we want to make sure that the plan document is drafted in such a way that it'll resolve these types of issues. Otherwise, there may have to be more complicated interpleader actions by the plan sponsor on behalf of the plan to resolve these sorts of things. There may be a competing claim that's mentioned by the aggrieved party. So again, what we want to do here is remind everybody listening who cares that to make your lives easier and avoid sort of like headaches like this, you want to regularly remind participants to review and, if desirable, revise their beneficiary designations. You kind of want to do this on a somewhat regular basis. You could do this perhaps as like a slip as part of any annual disclosures or anything like that. If there's a change in a life event that would allow for a mid-year enrollment under a health plan, kind of remind people about their beneficiary designations under their other benefit plans. So it's actually a really easy remedy. It takes seconds to avoid serious headaches going forward. So the reason I brought this up for today is because, again, it was timely. It was fresh in my mind, and we're seeing an increased frequency of this. Second topic, again, I'll be very quick. It's 5,500 season, and for calendar year plans, the deadline to file 5,500s is July 31, unless there's an extension through October for calendar year plans. And as a reminder, ERISA plans that are subject to an annual audit need to report accurately on line 4A of Schedule H if it's a large plan, or Schedule I for small plans, whether it was a failure to timely transmit to the plan any participant contributions within the time period described by applicable DOL regulations. So we're reminding you today that essentially that the time frame is the earliest date reasonably possible to remit employee contributions to a pension or welfare or health and welfare plan. For pension plans, it's the 15th day of the business day of the month following the month in which the contributions were withheld. For welfare plans, it's 90 days from the date such amounts were withheld by the employer. But this 15-day and 90-day metric, they're not there's not a safe, it's not a safe harbor standard. Rather, the standard that you're all required to abide by is the earliest date reasonably possible from which remittances or the money is withheld from the employee. So the metric for establishing that is essentially precedent. So if you're an employer and you regularly remit contributions within 2 days of being withheld, any day past that sort of 2-day precedent or pattern will be considered late. And so you're just reminded that you want to report accurately whether there have been any late remittances. And your auditor, your plan auditor, is going to check your homework, essentially, check the statement on your 5500. And your auditor can reflect this on the audit report. So important to this is if you're going to report any late remittances, excuse me, there's methods to correct it. It's through the DOL's VFCP program, or you could do so through self-correcting. The benefit of VFCP rather, is that you get the added comfort of having an abeyance of DOL action for the period in which you're reporting the correction, so it'll be under less scrutiny. However, VFCP is time-consuming, expensive. It's kind of a pain, and sponsors have to formally apply, show calculations, etc. For self-correction, that's probably slightly more advisable. However, there are pitfalls associated with self-correction in the sense that oftentimes employers will overcorrect through self-correction, and they'll remit a corrective contribution for participants that's greater than what it should be, and then they have to pull that amount out. So it can lead to more headaches. So both options are viable. You're just sort of cautioned to go through them carefully and correctly. So we're obviously here to help with that. Any questions regarding your 5500s, the 4As on the Schedule H or I? And sort of as a last minute reminder, in 2002, the DOL issued proposed changes to VFCP, which would make self-correction, I would give it more teeth. And it's been, as I said, about 2 years since we've seen any movement on that. But in March or April, the DOL representative indicated that imminently they'll be coming out with final revised VFCP guidance, which employers can refer to. But I caution, if you want to make sure that you report and correct any late remittances as soon as possible, even if the VFCP revised guidance hasn't come out yet. So as I said, we're happy to help. And that's basically it. So yeah, stay vigilant, people, and hopefully we'll be here to help if you have any questions. So that's it, Gabe, for me.
Devin, great. Thank you so much. Those reminders are really useful. We really want to stay on top of those updates. You're absolutely right. And so, as you said, it's fairly straightforward, but that you put it top of mind is important. And you and the rest of the employee benefits team is absolutely available to help. So let me turn to our third speaker of the day. And Devin, again, thank you. Now, I have the pleasure of introducing Nicole Macros, who's with us from our Syracuse office and who has been on the program previously, and wanted to share her insights concerning a recent decision out of the third department involving former Governor Andrew Cuomo versus the New York State Commission on Ethics and Lobbying in Government. Lots of interesting facts here to be reminded of, and I was chatting with Nicole a bit about this before we went live, and I think all of you as an audience will really enjoy hearing what has just come out of the third department. So Nicole, again, thank you for coming back on the program, and I look forward to hearing all these details so that you can bring our audience up to speed. The floor is yours.
Thanks, Gabe. Good afternoon, webinar viewers. Happy to be back to present today. As Gabe stated, I will be walking you through a recent decision from the Third Department Appellate Division. This is the Andrew Cuomo versus New York State Commission on Ethics and Lobbying in Government. This decision was entered on May 9th, 2024, so it's fairly recent. By way of background, in 2020, the Joint Commission on Public Ethics, which I'll refer to as JCOPE, approved a book related to the COVID-19 pandemic for publication, written by then New York State Governor Andrew Cuomo, who I will refer to as plaintiff. J. Cope subsequently commenced an investigation into the publication of the same book and charged him with ethics violations after he left office. In 2022, before the hearing was held on the ethics violations, the legislature replaced J. Cope with the New York State Commission on Ethics and Lobbying in Government, which I will refer to as the Commission. And this was created pursuant to the newly enacted version of Executive Law, Section 94. The commission was comprised of 11 members total by a nomination process. The executive branch nominated 5 members, 3 by the governor. The legislative branch nominated 6 members. The independent review committee then reviewed those nominations and approved and denied the candidates. So Executive Law, Section 9410 also granted investigative and enforcement authority to the commission. And as relevant here, I will give you some bullet points on this. So they were authorized to receive complaints of violations of Public Officers Law Sections 73, 73A, and 74. The Legislative Law Article 1A and 5B, and Civil Service Law Section 107. They were authorized to review complaints and determine whether to investigate the matter. They were authorized to prepare reports that set forth allegations, evidence, relevant law, and a recommendation pursuant to the investigation. They were also authorized to vote on whether to accept or reject the recommendation or direct the staff to further investigate the matter. They were also authorized to refer the matter to an independent arbitrator to conduct a due process hearing if there was credible evidence that a subject person committed a violation. And lastly, as relevant here, they were authorized to impose penalties or fines, refer the matter to the subject person's employer for a disciplinary action, or recommend the impeachment of a statewide elected official. Executive Law, Section 94, subsection 14, granted the commission the power and duty to administer and enforce all the provisions of the section. So the commission proceeded with the prosecution of the charges for ethics violations against plaintiff. And before any hearings were held regarding these charges, plaintiff commenced the action against the commission, seeking a declaratory judgment to find Executive Law Section 94 unconstitutional. So the Supreme Court ruled in favor of the plaintiff, granting the declaratory judgment, declaring Executive Law 94, subsection 10 and subsection 14, and all ancillary provisions unconstitutional. The commission then appealed, and this is where we ended up at the third department. So the Appellate Division, Third Department, affirmed the Supreme Court's decision, finding that the legislature usurped the executive branch authority to execute the laws, specifically Public Officers Law Sections 73, 73A, 74, the Legislative Law Article 1A and 5B, and Civil Service Law Section 107, in violation of the principles of separation of powers. So in sum, the court reasoned that pursuant to the New York State Constitution, the governor possesses the authority to execute the laws, and Executive Law Section 94 revoked that enforcement authority by granting the commission the authority to investigate the ethics complaints and impose penalties for violations. Executive Law Section 94 effectively created an agency with executive power, and the government and the governor had extremely limited control and oversight over the commission. And And instead, the IRC was granted authority that amounted to the functional equivalent of oversight power over the commission. So in an attempt to persuade the court to overlook this clear violation of the principle of separation of powers, the commission contended that the court could overlook the violation by looking to and relying on the legislature's motive or the beneficial purposes of the legislation, and that the creation of the commission fell within the flexible overlap of powers between the legislative and executive branches. The third department responded similarly to both of those arguments, stating in sum that it is a violation of separation of powers when a branch usurps power from another branch, thereby, quote unquote, expanding its own powers. So with respect to this specific fact pattern before the court explained that it is permissible for the legislature to delegate many of its own powers, but that the legislature was not authorized to usurp executive power to, quote unquote, faithfully execute the laws. So this is a fairly recent decision, and we will keep you apprised of any updates or legislative responses to this decision.
Nicole, thank you. As you pointed out, it's a May decision. The legislature has functionally adjourned for the summer. The governor's now considering bills that made it through both houses, and that'll be through the balance of the year. So we may not see anything move on this right away, but who knows? Maybe there will be activity. And either way, we look forward to having you back on the program when there's more to share, or of course, if there's another topic that you want to bring to the audience's attention. And we thank you so much for today's presentation.
Thanks, Gabe. I
So,
appreciate it.
Of course. And let me move to our final speaker for today, who is Cecily Capo. And Cecily is new to the program, and Cecily is as well part of our intellectual property team based in Syracuse. Cecily is involved in all manner of IP, including helping to protect clients, protect their innovations, and on previous programs this month, as I was walking through some of the windup of the New York State legislative cycle, I mentioned that there was a chance that the New York State Privacy Act would make it over the finish line for the governor's signature. It ended up that it did not. What Cecily is here to talk about is federal activity around privacy. So really this is part of a broader national story around regulating privacy in a day where data are handled differently and with a volume, I should say, that is so differential relative to even just a few years ago. So Cecily, really excited to hear what you have to say about this proposed legislation, and welcome onto the program. Looking forward to learning from you.
Thank you, Gabe, and thank you for having me. So today I'm going to go over a brief overview of the American Privacy Rights Act. So the American Privacy Rights Act is a proposed legislation that was introduced in April of this year that proposes a single comprehensive federal data privacy law. So if enacted, this law will provide for enhanced consumer protections, increased transparency, and data minimization, all while eliminating the patchwork and state-specific data privacy protections that are currently in place, aiming to create a unified standard for data privacy across the US. Now, we were going to get into a few key aspects of the proposed American Privacy Rights Act, but first let's go over who this act will likely apply to. Next slide, please. So the American Privacy Rights Act will apply to most individuals, entities, and nonprofits who collect, process, and retain or transfer covered data. And covered data has been defined to include any information that identifies or is reasonably linked to an individual or a device. And of an important note, small businesses that do not collect this data are likely to be exempt under this proposed act. And as of right now, a small business has been defined as those who have $40 million or less of average annual revenue for the preceding 3 years and do not collect personal data of more than 200 individuals and do not sell any personal data. Next slide, please. And over the next few slides, I've highlighted a few key aspects of the Act. Now, this is a fairly comprehensive proposed legislation with a lot of details, so this is not a full overview of everything that you need to know, but a few key aspects include enhanced personal data protection. So one key aspect of this Act is to give individuals greater control over their personal data. For example, a covered entity will be required to obtain the affirmative consent from individuals in order to transfer their sensitive information. And this includes things such as genetic and biometric information, financial account and payment data, and geolocation. And additionally, individuals will be given the option to access, export, correct, or even delete their data that's held by a covered entity, and restrict how their personal information is used for targeted advertising purposes. Next slide, please. Another key aspect is increased transparency. So a main goal of this proposed act is to keep individuals informed of their rights with respect to data privacy. The act will require covered entities to make their privacy policy publicly available that defines the category of data that the covered entity will retain, the length of time that that data will be retained, and then the purpose that it's being retained for. Additionally, if a covered entity makes a material change to their privacy policy, the individuals must be given notice of that change and also be given the option to opt out of their privacy policy. Next slide, please. Lastly, data minimization. So another goal of the proposed act is to prevent the unnecessary collection of user data. So the act proposes a restriction on the data that's collected that falls outside of a specific and explicit purpose. This requirement is largely modeled after the European Union's General Data Protection Regulation, or GDPR. So what this means is that the covered entities will be restricted to collecting data within what is necessary, proportionate, and limited to the purpose of their business. And this in turn will encourage entities to only store information that is needed rather than storing all information and determining what is useful later on. And on the next slide, we've highlighted a few key takeaways. So first, this act is not in place yet. It still faces a vote by both the House of Representatives and the Senate. However, there is a 180-day effective date, which means that if this bill is passed, it will become effective 180 days later, which is a relatively short turnaround time. Therefore, it's recommended that entities that will likely fall under the definition of a covered entity review their data privacy policies and stay informed of any developments with respect to this act. And with that, I will turn it back over to Gabe.
Thank you very much, Cecily. That's a really helpful overview of this federal legislation. As you point out, if it ultimately is enacted and becomes law, 180 days is really very quick when you're dealing with data of the kind of volume that the law hails in. And so thank you for bringing this group up to speed. And we'll be tracking it as well as the activities around the nation as we've been doing in previous iterations of the Tuesday webinar. So Cecily, you're always welcome back to provide updates on the federal legislation as well as anything you hear about happening across the country that would be germane. So with that, I'm looking at the Q&A and I don't see any questions in the chat that we haven't yet responded to. So what you have here listed are the emails for the presenters today. If you have questions that you would like to handle offline, feel free to write any of us and we'll gladly respond as best we can. This will be our final broadcast for the month of June, and we are moving into July. On the 2nd, you'll be with Kristen Smith. I will be back with you on the 9th. And in the interim, I'm wishing you all a really meaningful 4th of July holiday and a terrific start to the summer. And in the meanwhile, have a great afternoon.